Recently, we saw convictions from the office of the DPP, arguably the first public conviction as far as corruption is concerned. The case that involved Waluke, Engineer Waluke, Major Waluke, the MP, who was convicted of corruption in the cereals board scandal. And they were sentenced to 67 years in prison, but they recently got out, right? They appealed the decision, and that happened, they're out. Then, and the accusation was they had stolen, they had taken away millions, hundreds of millions of government Kenyans' money. Then I recently came across an article of a Nairobi University lecturer who received a bribe of 3,000 shillings from a student, and he had been sentenced to 3 years in jail. 3,000 shillings. Isn't that a disparity to encourage people to steal big? You steal enough to pay lawyers, you steal enough to survive, to buy justice?
You say there's an old Kiswahili saying, ukitaka kula nguruwe, kula aliyenona. But let me go back to the question that you've asked, and I must think like a lawyer in this regard. I think like a lawyer that when people are convicted on the basis of evidence that has been adduced in court, that is the proper thing. So I'm very slow to condemn the judiciary. The judiciary administers justice according to law. And there is a difference between justice according to law and truth. Truth is a totally different thing. If they coincide, well and good, but it's justice according to law on the basis of the evidence that is adduced before them. Then the law does allow for people who have been convicted to seek bail pending appeal. There are principles that guide that. If the judge or the presiding officer is satisfied on the basis of the evidence available that indeed there are grounds to justify releasing people on bail pending appeal, then he or she may exercise his discretion in their favor. And if the other side is dissatisfied, then they may appeal. So what is happening is also very useful for our jurisprudence because it's beginning to test our jurisprudence. It may be very unfortunate that the people want Jesus to be hanged, but once you have chosen the path of justice according to law, it is painful, it is slow, sometimes it is even disappointing. Because the other alternative is this, that if Dr. Kingori here is accused of corruption, because our judicial system is very slow, we take you to Uhuru Park and we call the people and we ask them, as many are of the view that Dr. Kingori is a thief, say hi. And when they say I, we stone you. That would be the law of the jungle. So once we have chosen this path of taking you through the process, we must also suffer the pain of waiting for that process. Sometimes it is unfair, sometimes it looks unreasonable, sometimes it looks like it is protecting the rich, sometimes it looks like it is really running roughshod over the things that we desire. But unfortunately, the law says it is better than a possibly guilty person be let free than for an innocent person to be convicted.
One thing that I've never understood, what you said, what is facts according to the law and the truth. So in your experience, because I know you've covered the law inside out, a judge would know, and this I've never understood, a judge would know that a person is telling the truth or a person is lying, but let's take the case of a person telling the truth, going to prison because he could not prove his case. As in, the judge as a person would know the truth, but as a person, the judge would side with the law, even knowing that the facts are different on the ground.
Suppose I am a judge, and I'm trying a murder case, for example.
Yes.
And I'm aware in my other capacity, because I'm a member of the society, and I therefore live in the society, and I know.
Yes.
And then the matter is brought to me. Yes. Do I decide that case on the basis of my knowledge outside of the law? No. What I should do is that I should be moved only by the evidence. Easier said than done, but the only thing that should move me as a judge when I sit in the seat of authority to judge according to law and to sit in judgment of my fellow countrymen and women, I'm only moved by one thing: the law or the facts as tested against the law. And many people don't understand this. For example, somebody has killed. We saw him shooting the person. We saw him killing the person. Hii kitu mnaita manslaughter ndio nini? Si aliua. Watu watahoji hivyo.
Yes.
So those are things that we must live with, because it is the path that we have chosen. And it's not only because we borrowed English law. If you go into the history of many of our nationalities, whether they are Gikuyu, or Embu, or Luo, or Kalenjin, or Luhia, there were means and ways of dealing with these things. If you killed deliberately, there would be a penalty. If you killed by accident, there would be a penalty for it. And that is the way it is.
So as a judge, if you saw someone kill someone and you come to judge the case, you pretend you did not see them. You now go back to the law side. That
is a little bit too simplistic, perhaps, but it makes my point. It makes my point that even if you have information,
yes,
the only thing that should move a judge,
yes,
is the facts as presented by the prosecution.
Okay, then I can be a good judge because I can pretend I did not see anything.